Okay, good morning. The time is now 10:01, and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me for this meeting are board members Charles Nottingham, who is with us by telephone, Felice Smith, Darrin Sobin, and Melissa Tucker. Together, the five of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask the board to please take a moment to review the agenda, and then we'll need a motion to adopt the agenda.
Motion?
Okay, is there a second?
I'll second that.
It's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
Aye.
No nays. Hearing none, the board has adopted the agenda for today's meeting. The next item are the minutes from the June 2026 draft, June 2026 meeting. Those are draft minutes, and I'll ask the board to review those, and then we'll need a motion to approve the meetings from June.
Move to adopt?
Okay, is there a second?
Second.
Okay, it's been moved and seconded that the board consider approval of the June 2026 meeting minutes. All those in favor, please indicate by saying aye.
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 Any nays? Hearing none, the board approves the June 2026 meeting minutes. So the next item on the agenda is a report from the Office of Open Government. We'll hear from Director Allen. Please proceed.
Thank you, and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act's requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. First in my report are Open Meetings Act and Freedom of Information Act advice rendered by the office. Advisory opinions, dismissal of Open Meetings Act complaint, White House law enforcement issues, number OOG 2026-0013. I recuse myself from this matter due to the appearance of a conflict of interest pursuant to DC Official Codes Section 1-1162.23a and assigned it to the Chief Counsel to review and issue a determination on my behalf. On June 30th, 2026, Chief Counsel Louis Neal dismissed this complaint against the White House and the Executive Office of the President of the United States, which alleged that no action was taken by the White House and the Office of the President on information that could be a threat to domestic security and the rule of law. Chief Counsel Neal found that the White House and the Office of the President are not public bodies that are subject to the Open Meetings Act. As such, the Chief Counsel dismissed the complaint pursuant to 3 DCMR Section 10403.1a because it did not raise issues within my authority under the Open Meetings Act. He informed the complainant that for allegations of misconduct related to federal official or administrative policies, the complainant may consider contacting the relevant U.S. representative or senator to launch an inquiry. This matter is closed with respect to OOG. A copy of the complaint and the dismissal letter are in Dropbox. Informal advice. Since the last board meeting, OOG has responded informally via email, telephone, or teleconference to requests for assistance as follows: 11 requests for Open Meetings Act advice, 3 requests for FOIA advice, and 12 requests for assistance with open-dc.gov. Meeting monitoring. OOG staff attends public body meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and the OOG's central meeting calendar for public meeting notices and records. OOG's attorneys provide legal advice on Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff have attended 13 public body meetings. As a result of the monitoring, 1 corrective measure was communicated. The public body failed to publish a complete meeting notice pursuant to the Open Meetings Act. Training and outreach is next. Practicing Law Institute Professional Wellbeing Seminar. On June 9, 2026, I completed the webinar, Take Control of Your Wellbeing, Mental Health, and Wellness for Attorneys. This 3-hour course provided tools for coping with perfectionism, managing stress, and setting boundaries to maintain well-being and enhance attorney competence. Next is the Office of the Attorney General for the District of Columbia, OAG, rulemaking training. On June 10th, I, along with OOG staff, attended the OAG rulemaking training presented by Senior Assistant Attorney General Lori Ellsworth and Assistant Attorney General Josh Turner of the Legal Counsel Division of OAG. The training session covered rulemaking processes in the District of Columbia, which included potential legal issues. Next is Open Meetings Act training for boards of trustees for DC public charter schools. On June 10th, Attorney Advisor Joan Lelma facilitated an Open Meetings Act training for the Board of Trustees for DC public charter schools. The training was the third in OOG's 2026 training series for the public charter school boards. I, along with Chief Counsel Neal and Attorney Anthony J. Skirbo, attended this training. Open Meetings Act training for the Board of Podiatry. On July 8th, Attorney Skirbo facilitated an Open Meetings Act training for the Board of Podiatry. The training provided in-depth examination of the application of the OMA to public bodies. Next is the litigation and legislative update. Litigation is first. America First Legal Foundation versus Centers for Disease Control and Prevention, case number 22CV00978 in DC District Court. This is a Federal Freedom of Information Act case in which the plaintiff requested that the defendant, Centers for Disease Control, produce all records of its efforts to flag COVID-19 or COVID-19 vaccine-related is, quote, misinformation or, quote, disinformation on social media, including any communication with social media companies. After receiving no response to its request, the plaintiff filed suit to compel production. The defendant subsequently released all responsive documents, portions of which were not disclosed under various FOIA exemptions. The plaintiff disputed some of the withholdings. In response, the defendant re-reviewed more than 1,000 pages of records and released some previously undisclosed materials and provided plaintiff with a draft Vaughn Index explaining the remaining withholdings. The plaintiff continued to dispute the non-disclosure with the following information. 1, all Exemption 4 withholdings related to brand lift and crowd tangle, an advertising measurement platform and social media analytics tool, respectively, devised by Meta Platforms Incorporated. 2, all Exemption 5 deliberative process withholdings, and 3, all Exemption 6 withholding of names only. The defendant later released information previously withheld under Exemption 6. Both parties moved for summary judgment as to the information withheld under Exemptions 4 and 5. The district court granted in part and denied in part the parties' cross motions for summary judgment. The court held that the records withheld under Exemption 5 were properly protected by the deliberative process privilege because the materials included including meeting agendas and summaries, or pre-decisional and deliberative. The court rejected the plaintiff's argument that allegations of unlawful government conduct defeated the privilege, relying on D.C. Circuit precedent, declining to recognize a government misconduct exception to Exemption 5. The court further held that portions of the Meta Brand Lift report were properly withheld under Exemption 4 because the information consisted of confidential commercial information, including pricing structure, budget terms, and account information whose disclosure could create competitive harm. However, the court determined that records related to Meta's CrowdTangle tool were improperly withheld because the agency failed to establish that the information was commercial in nature, confidential, or that disclosure could create foreseeable commercial harm. A copy of the court's decision is in Dropbox. Next is legislation and rulemaking. First is Open Meetings Clarification Amendment Act of 2026. I previously reported on Bill 26-208, the Open Meetings Clarification Amendment Act of 2026. On June 2nd, the D.C. Council Committee of the Whole issued its committee report and markup of the bill, which clarifies the definition of a meeting. This is a quote, establishes that a meeting should be deemed open to the public if the public body takes steps reasonably calculated to allow the public to view or hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. The court passed the bill on first reading on June 2nd by a vote of 9 yes, 2 no, 1 present, and 1 absent. An amendment by Councilmember Allen, which added a quote, a new post hoc notice requirement for gathering of council members that are otherwise not subject to the Open Meetings Act, passed by a vote of 12 yes and 1 absent. On June 23rd, Chairman Mendelson proposed an amendment to the bill to quote, make clarifying changes to the language adopted by the amendment on first reading and quote, change the Secretary of the Council of the District of Columbia to the appropriate officer of the council to ensure that a non-statutory position is not mandated to take action in the statute. The amendment also acknowledged that the appropriate officer in cases related to compiling and posting these open meetings documents is likely to be the Secretary of the Council. The amendment was proposed to eliminate unnecessary duplicative language that attempted to describe the conduct or subject matter of one of these meetings and to explicitly exempt text messages from constituting an electronic meeting. The amendment passed unanimously and the bill passed by a vote of 10 yes, 2 no, and 1 present. It was transmitted to the mayor on June 26 and returned without the mayor's signature on July 6. It is enacted as of July 14th as Act 26-0361. The 30-day congressional review period will follow. I will note these bills in Congress that seek to undo the changes proposed in the original bill have been assigned to the House and Senate committees, though currently no further action has been taken. A copy of the act, the amended bill, Chief Counsel Neal's written response to the council concerning the original bill, and the then passed council measure are in Dropbox. Next, emergency and temporary amendments to the body-worn camera regulation reporting Requirements Act of 2015, which are FOIA related. The first is Act 26-0290, the Full Accountability and Arrest Reporting Emergency Amendment Act of 2026. The act requires MPD to release body-worn camera footage whenever an MPD officer is present during a serious use of force incident, even if the force is used by federal officers, and requires the release of all names of law enforcement officers involved. The act expired June 29, 2026. The companion Act 26-0304, the Full Accountability and Arrest Reporting Temporary Amendment Act of 2026. This measure was enacted without the mayor's signature on April 29, 2026, published in the D.C. Register on May 1st, and became law on June 11th. This law will expire on January 22nd, 2027. And next is Act 26-0305, 0305, the Body-worn Transparency for Use of Force Temporary Amendment Act of 2026. The act requires MPD to release body-worn camera recordings in the event of an officer-involved death or serious use of force by law enforcement officer other than an MPD officer. The temporary measure, Bill 26-0617, was passed by the council and signed by the mayor. The act 26-0305 was published in the DC Register on May 1st, and it became law on June 11th and will expire on January 22nd, 2027. Legislative action regarding the Captive Insurance Company Act of 2024, which is FOIA related. That should be 2026. On June 15th, 2026, the Council's Committee on Health held a public hearing on Bill 26-0588, the Captive Insurance Company Amendment Act of 2026. It was introduced by Chairman Mendelson. The proposed amendment reads as follows, quote, documents, materials, and other information submitted pursuant to this section and any rules promulgated thereunder shall be confidential and shall be exempt from the Freedom of Information Act of 1976 and shall not be subject to subpoena or discovery or admissible in any in any evidence in a private civil action and shall not be divulged to any person except either as provided for in this subsection or with the written consent of the captive insurers or protected cell. The Captive Insurance Company Act of 2024 DC Law 15-262 applies to an insurance company created by a parent company to insure the parent company's own risk, a captive insurance company. This Captive Insurance Company Amendment Act of 2026 makes certain proprietary captive insurance regulatory records confidential under the statute. While these records could have already been withheld under DC Official Code Section 2-534A1, which exempts trade secrets and confidential commercial or financial information, this new law would clarify the extent of confidentiality of captive insurance company records submitted to the Department of Insurance and Banking, or DISB. The primary justification for withholding records is now DC Official Code Section 2-534A6, information specifically exempted by statute as a result of the amendment. We will continue to monitor the progress of this legislation, and a copy of OOG's internal memorandum, the bill, and the DC Open Government Coalition's testimony regarding the bill are in Dropbox. Last is Director of Open Government's notice of final rulemaking regarding the Open Meetings Act closed meeting requirements. On June 16th, I issued a notice of final rulemaking and adopted as final amendments to Chapter 104, Title 3 of the District of Columbia Municipal Regulations. The rulemaking creates a new section 10411 that sets forth the procedural requirements public bodies must follow to enter into closed sessions of meetings covered by the Open Meetings Act. Additionally, the rulemaking makes clarifying and conforming amendments consistent with the OMA. Previous versions of this rulemaking contained a new subsection that authorized votes to enter closed sessions of public meetings at previous board meetings. The Office of Open Government received several comments that this section was problematic and may compromise the spirit of the Open Meetings Act. In response to the second notice of proposed rulemaking published in the DC Register on May 15th. To address those comments, the final rules adopted on June 16th do not include that subsection, and OOG will take up that matter in a separate rulemaking. The new rules took effect upon publication on June 26th and are posted on OOG's website, open-dc.gov. A copy of the amended notice of final rulemaking and the DC Open Government's response to OOG's second notice of proposed rulemaking are in Dropbox. Last is administrative matters, FY 2027 budget oversight. The DC Council conducted a legislative meeting regarding the fiscal year 2027 Local Budget Act of 2026 on June 23rd. The Local Budget Act passed unanimously with amendments, including Bega's budget for $4 million $92,650 for FY 2027. The DC Council conducted a legislative meeting regarding the fiscal year 2027 Budget Support Act on July 7th. The BSA with amendments was unanimously approved by the DC Council. The BSA includes a telework provision that provides the mayor with the authority to establish a government-wide telework policy. The legislative branch, judicial branch, and certain independent agencies are exempt from the mayor's authority. Telework remains a permissible subject of collective bargaining for future collective bargaining agreements. This concludes the Office of Open Government's July 9th, 2026 report. I'm happy to answer any questions the board may have.
Thank you, Director Allen. Are there any questions for Director Allen? Then next.
Well, just real quick, I'm not sure how much you've delved into the body camera transparency, accountability stuff, but as I understand it, they're saying that MPD officers have to disclose the identity of the arresting officers as well as the body cam footage, whether they are MPD officers or federal officers. Is that correct?
That's correct.
And it passed legal sufficiency? That
it did.
Okay. All right. And there have been no judicial challenges yet to that?
Not yet.
Okay. Well, we'll keep an eye on it.
Yes.
Thank you.
You're welcome.
Okay, thank you. Next on our agenda is a report from the Director of Government Ethics. Director Cooks, please proceed.
Morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, Director of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have a grand total of 73. Open undocketed matters, we have a grand total of 14. Pending state investigations by status, we have 33 matters that are closed pending collection, 3 matters in DC court case, 2 matters stayed for U.S. District Court case for a grand total of 38. For regulatory matters by status, we have 61 matters that are closed pending collection, 631 matters that are open for a grand total of 692. Again, we currently have 73 open investigations and 5 matters that are stayed. The number of open preliminary and formal investigations includes 13 new matters. The investigative team resolved 18 investigations since the board last met. This total does not reflect the complaints that were dismissed for a lack of jurisdiction. Next is an update on training and outreach. First is professional development trainings attended by staff. Since the last board meeting, General Counsel Asia Stewart Mitchell completed PeopleSoft training using and managing the DCP card. Supervisory Attorney Advisor Amber Anderson completed PeopleSoft trainings, building high-performing teams and performance management MSS. For training conducted by staff, since the last board meeting, OPE conducted 7 training sessions, which includes 2 HATCHAC trainings, the monthly brown bag session, 2 new employee orientations, lobbyist training, and the quarterly outside employment training. In June, 732 district employees completed ethics training using and 473 new employees attended employee orientation and received information on the district's ethics rules. For an update on advisory opinions and advice, first is informal advice. OGE's legal staff provided advice for approximately 33 ethics inquiries, which is 7 less than the 40 reported at the June board meeting. This number does not include responses we have provided to questions regarding lobbyists and FDSE filing systems. For formal advisory opinions, OGE issued 1 advisory opinion in response to a request since the last board meeting entitled Outside Activity by a Board Member. The opinion addresses whether a board member of the Alcoholic Beverage and Cannabis Administration Board can represent an establishment that serves alcohol in the member's private practice. I concluded that the member could represent the client in his private practice because the representation rule provided in DPM section 1807 as it applies to special government employees, only applies to matters pending before APCA and the APCA board. And the financial conflicts of interest statute requires the member to recuse from any matters involving this client that comes before the APCA board. The opinion is posted on the Bega website and it will be published to the DC Register on July 10, 2026, with the comment period closing on August 10, 2026. Next is an update on legislation and rulemaking. The financial disclosure rulemaking, that is B26-0325, Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025 is still pending. This legislation is in response to Bega's rulemaking, which designated 43 boarding committees as public financial disclosure statements and will repeal Bega's authority to make such designations in the future. There has not been any action taken on this legislation since the April 18, 2026 council meeting, when the council passed temporary legislation that halts the applicability of Bega's rulemaking until October 17, 2026. Next is an update on OGE administrative matters. First is staffing. OGE has 2 attorney advisor vacancies, which we plan to fill in the coming months. Bega welcomed 2 SYEP interns, Alkia Miller and Maurice Hall, last month. We look forward to a productive summer with our new addition. Also, I'd like to wish our legal assistant, Courtney Brown, luck as she sits for the bar exam at the end of this month. Next is an update on budget. On June 23rd, the council approved, On June 23rd, the council approved the FY27 budget, which includes Bega's budget of $4 million. On this past Tuesday, the council approved the FY27 Budget Support Act of 2026, which proposes to transfer $102,000 from the lobbyist fund for years 2027 through 2029, and a transfer of $152,000 from the lobbyist fund and $19,000 from the accountability fund in fiscal year 2030. The BSA also includes a subtitle which will amend the lobbyist section of the Ethics Act. Specifically, the amendment will increase registration fees by $150, which means general lobbyists will pay $500 and nonprofit lobbyists will pay $250, with the additional $150 going to the district's general fund. This amendment will also require 501c4 organizations to register as lobbyists, increase the late filing penalty to $200 per day, and remove the exclusion of Saturdays, Sundays, and weekends from the late filing time frame. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the financial conflict of interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The deadline to file the financial disclosure statements was May 15, 2026. As of July 6, 8,254 filers, or 92%, had completed their filings. Next is an update on lobbyist registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $200 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the concerning the registrant's lobbying activity during the previous quarter. On June 18, 2026, Quarter 2 lobbyist report opened and the lobbyist registration and reporting system was opened. The deadline to submit Q2 activity reports is July 15th. OGE conducted a lobbyist training on June 24, 2026. And last is an update on public investigations. There's just one that is 46-0005F in Refill Mendelson. This is a form based on allegations that the respondent, chairman of the DC Council, misused government property and resources to oppose a political candidate's declaration of candidacy with the Board of Elections. Thank you. This concludes the Office of Government Ethics, July 19, 2026. I welcome you that you have.
Thank you, Director Cooks. Are there any questions for Director Cooks?
So originally they were going to take our entire O-type fund for lobbyist registration. And then they decided that instead they'll just increase the registration fees and take that money instead.
So the council, the proposal is to sweep the entire fund to make it a lapsing fund. That was last fiscal year's BSA. This FY26's BSA, which would apply in FY27, initially there was only a $28,000 sweep from the lobbyist fund. But in order to generate additional revenue for the district, the council has changed the legislation to increase the lobbyist fees, and then they have increased the sweep based on that increase, the projection that
Right.
the increase will cause.
Well, I guess sort of an artful solution to what they wanted to do, but I mean, it's not going to affect our budget one way or another since they're taking the money that they're increasing the registration fee by.
If that projection is correct.
Okay, well, we can keep our fingers crossed.
Any
All right.
other questions?
Thank you.
Okay. We want to welcome Ms. Miller and Mr. Hall and hope you have a great summer. I'm sure
And
you
good
will.
luck on the bar exam.
And good luck on the bar
That's-
exam.
By the way, the DC Bar has a law student support group for those about to take the bar exam and are stressed about it. So if you're interested, and I don't know anyone who wasn't stressed.
All right. Then the next item on our agenda are public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Any members of the public? I don't see anyone who doesn't look like they belong to us. Okay, so since there are no comments from the public, we will proceed with the next item on the agenda, and that's the executive/closed session. This next agenda item is a closed session to discuss ongoing confidential investigations pursuant to DC Official Code, Section 2-575B14, to consult an attorney to obtain legal advice and preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code, Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code, Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code, Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code, Section 2-575B2. May I have a motion to enter into executive session?
So moved.
Is there a second? It's been
Second.
moved and seconded that the board enter into executive session. All those in favor, please indicate by saying aye.
Aye.
Okay, the motion
Aye.
passes unanimously. The board members, please move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report out on any matters decided, finish any other business, and adjourn the meeting. Thank you. Hey, the time is now 11:14 a.m. and we are back on the record. In the executive closed session, the board approved two negotiated dispositions. The first is 25-0116-P in re Stephen Hamlin. The second is 26-0013-P in re Tamika LeRae. The board also approved an amended scheduling order in 26-0004-F in Re Cleo Subido. The next board meeting will be held here at the Board of Ethics and Government Accountability at 1230 15th Street Northwest, Suite 700 West, and virtually on August 6, 2026 at 10 a.m. Thank you. See you then.
Bye, everyone.
All right. Safe summer.
Yes. Guess I will see you.